Hi, I'm David Slonim of Slonim and Lemieux, and welcome to another episode of the 4 Minute Lawyer series. Today, we're going to be discussing whether or not a probate will be necessary even if a person has a revocable trust. This is something that we get fair amount in the office. Is a question that comes up when clients come in. They may have had a trust done somewhere else, or they may have been told that a trust is going to be necessary by somebody else. So let's go over some of the issues that have come up. First, with respect to creditors, any asset in a trust just by itself does not necessarily protect it from creditors. However, with a probate administration in Florida, then creditors have only 90 days to file a claim against the estate once that estate has been opened. And so there's a certain period of time that most creditors will have to file. If a probate administration is not initiated and the notice to creditors is not done, then creditors may have up to 2 years to file a claim against the estate. This can sometimes just cause an issue, consternation or otherwise, by the beneficiaries or other family members of the deceased, because then they just have to be looking over their shoulder, so to speak, for the next couple years, and creditors could be all sorts of things at that time. So usually a probate administration at least creates a peace of mind in that respect there. Also, putting your homestead in a trust is not always going to be the best way to go. There's a lot of variations of why that's going to be the case, and I always recommend talking to a good estate planning or probate attorney to understand why having that homestead not in a trust. Used to be that we would put the homestead in trust pretty much all the time. But with fairly recent case law and a good understanding of the statute, it's usually the case these days not to put it into the trust. Also, non homestead real property is a potential problem sometimes when we have things like Medicaid or other government benefits that could have significant liens against the estate. And even if a non homestead property is in a trust, that's not protected against the liens as well, kind of like a creditor situation. So you do want to be very cautious with respect to that. Now, on the flip side, having a non homestead property in another state, and if you were to reside in Florida and pass away here, that I do recommend having that asset in a trust, but that doesn't necessarily mean that you shouldn't have a probate administration to go along with that trust asset and trust administration. So just bear that in mind overall. Also, digital assets, your PayPal account, Bitcoin account, or various other accounts that may have no beneficiary designation. Those generally aren't going to be handled by a trust or even have an opportunity to be owned by a trust exactly. So, unfortunately, a probate administration will be necessary to administer those assets after you pass away. And certainly, if there are accounts like email addresses or other things like that that require a proper personal representative to act, then the trust doesn't create that power. So a probate administration is still going to be necessary. Thanks again. Subscribe if you like it.